May I now ask on Dr. Fred Logue, please.
Thank you, Chair, members of the committee. I'd also like to make a very brief submission about the information law aspects of the bill. I practice in information law and I act for individuals and public and private sector organisations. And in particular, I'd like to make a comment on the handling of personal data, which comes within the scope of EU law and the General Data Protection Regulation and the Data Protection Act. And to point out that under the doctrine of primacy of EU law, that any national law which conflicts with EU law must be set aside, and that obligation is on public authorities. So insofar as the bill, or if it becomes law, would conflict with the General Data Protection Regulation, the National Archive as a public body would be bound under the treaties to actually disapply it. So some of the aspects of the bill, which I'll discuss in a minute, are, if enacted, in my view, would not even be binding on the National Archives. I think and even under Irish law, I think it's impermissible to pass legislation which completely seals records. Under the Constitution, the courts have full and natural original jurisdiction, so the High Court can order access to records. And actually, more importantly then, I think that the provisions of the bill need to be understood to be without prejudice to data subject rights, including the right of access. And I would recommend that the bill be amended or changed to give express provision for that, to recognise that any aspects of the bill which put records beyond reach are without prejudice to data subject rights. The second thing I'd like to say is I don't think there's a concept in Irish law of sealing a record. I did a very brief search on the statute book and I couldn't find any other legislation that dealt with that. It seems to be that it's over and above withholding it from public access. And my fear is that sealing will be interpreted narrowly, as in that there'll be no access whatsoever, even internally within the National Archives. And certainly it'll probably be interpreted as there'd be no access if there's a dispute about access or if there's a subject access request. So I think that is a very weak provision in the bill. So I think, as my colleague noted, that there is already provision in the National Archives Act to protect particular interests. I also observed that in the FOI Act and the GDPR itself, there are provisions which protect both private and public interests which could be harmed if access was granted or publication. And again, I would raise the question as why those provisions aren't suitable to protect the interests that this bill seeks to protect. So I think, in summary, I think the bill could be strengthened by expressly recognising rights of access as directed by the courts, as rights of data subjects, and then ancillary access to give effect to those rights. So the Data Protection Commissioner must be able to order access to personal data, and the staff of the National Archives or their contractors must be able to access the archives in order to give effect to those rights.
Thank you very much.